Florida estate and trust litigation, and offers of judgment. What do you need to know about the civil rules of procedure when they apply? Hello, my name is John P.L.C. I'm going to be speaking to you today about the offer of judgment rule in Florida if you're in the middle of civil litigation in Florida or any probate litigation in Florida. Now, you can ask Florida probate attorneys about the Florida probate rules or the probate code or the trust code, and they may know a lot about it. But you really need to ask a Florida or state litigation attorney about offers of judgment and the rules of civil procedure. More specifically, Rule 1.442 and Florida Statute 768.79. Now, our law firm handles lawsuits, trials, and appeals regarding wills, trusts, estates, probates, guardianship litigation, as well as business and commercial litigation, and some related issues involving real estate financial accounts. But what do Florida clients and attorneys need to know about offers of judgment and proposals for settlement if they're involved in a probate or a petition to revoke probate or a will contest? Well, I'm going to tell you. We know that in certain proceedings in the estate or probate proceeding, whether you're in Hillsborough County, Palm Beach County, Miami-Dade County, the proceeding can be adversary under the Florida probate rules. This means that the rules of civil procedure apply. Now understand the rules of civil procedure are slightly different than the Florida probate rules. Your Florida trust lawyer should know that. Also, your Palm Beach estate attorney should know that. But your Florida probate litigation law firm definitely needs to know that. So why does this all matter? Well, if you're in the middle of an estate or a trust inheritance lawsuit and the rules of civil procedure apply, you can move for default, you can get defaults, you can move for summary judgment, and you can use the offer of judgment statute. The offer of judgment statute or proposal for settlement statute and rule permits somebody to make an offer to settle the matter with the other party. And if they reject it under certain circumstances and you prevail under certain circumstances, you have a statute and a rule to seek fees from the other side if they rejected your offer of judgment, if they rejected your proposal for settlement under certain conditions. You need to read Rule 1.442 of the Florida statutes, the so-called offer of judgment rule, and you need to read Florida Statute 768.79, the offer of judgment statute or the proposal for settlement statute in Florida. There's a very recent case that was decided just a few days ago on May 11th, 2016. Today is Friday, the 13th, May 13th, 2016, so this is fresh. This is out of Florida's 3rd District Court of Appeal. The 3rd DCA in Florida heard the Manuel Diaz Farms Incorporated case. Manuel Diaz Farms Incorporated versus Delgado. It is 3D, 3rd District 15, a 2015 case, -86, literally handed out 2 days ago. And in this case, somebody made an offer of judgment, a proposal for settlement to the other side, which was rejected. There was a motion for attorney's fees. The motion for attorney's fees was denied at the Florida trial court. It went up to appeal. The party that was opposing the motion for attorney's fees said, hey, the proposal for settlement or the offer of judgment was too vague. There was an issue about releasing somebody, and the proposal failed to properly address non-monetary relief, resulting in an ambiguous proposal that was invalid as a matter of law. The offer of judgment statute and the rule, the proposal for settlement matter in Florida, requires that you generally handle monetary damages, not equitable relief, and that the other side understands what they're giving up or releasing or agreeing to. So you want to try to avoid ambiguities. Now, when you have an offer of judgment which is required or conditioned upon a release of the parties, that's where you can get into trouble. So I'm going to give you the 4 or so cases that you need to read about offers of judgment and releases. If you're a defendant in a trust or an estate lawsuit and a proposal for settlement or an offer of judgment has been sent to you under Rule 1.442 of the Florida rules, you need to know how to respond to that. You want to read this Manuel Diaz Farms case, and I'm going to give you a couple more cases that you'll want to read. The Darrow v. Gilmer case, 2nd District Court of Appeal from 2010, 35 Florida Law Weekly, D as in dog, 2417. Check out Jones v. Publix Supermarket, a September 7th, 2011 case. 2011 Westlaw 390-3179. That is Jones v. Public Supermarket from Florida's 4th District Court of Appeal, Florida's Palm Beach Appeals Court. Two other cases that you want to consider reading, one, Alamo Financing versus Mazoff, M-A-Z-O-F-F, an April 24, 2013 case, 2013 Westlaw 174-8597. All of these deal with Rule 1.442 and Statute 768.79, Florida's offer of judgment, proposal for settlement in Florida civil trial litigation. Not necessarily probate cases or estate cases, but when a proceeding is adversary under the Florida probate rules, the rules of civil procedure apply, so you can use the offer of judgment statute. Remember the law in Florida for attorney's fees. The general rule is that everybody pays their own fees, right, unless attorney's fees are permitted by a contract or a statute. This is one of those examples. You can use a statute to try to get attorney's fees as part of your probate litigation trial strategy from the other side. So in this particular case, the appellate court reversed the trial court and remanded it back for a determination of attorney's fees, saying this wasn't ambiguous. It wasn't invalid as a matter of law. So what's your takeaway from this probate litigation commentary for Florida trust lawyers and Florida probate lawyers? Well, if you're involved in probate litigation, understand whether the proceeding is adversary under the probate rules. If the proceeding is adversary, can you take advantage of the offer of judgment or the proposal for settlement rule, Florida Rule 1.442, and the statute, the offer of judgment statute, 768.79, and can you use that as part of your probate trial strategy in Florida to help your clients against the other side? If you read these cases, you'll learn just about everything you need to know about offers of judgment when there's a release conditioned when there's an offer of judgment conditioned upon a release. This concludes my remarks about this estate litigation topic in Florida about offers of judgment and proposals for settlement.